this bill now be read a second time. I call the member for Maitland.
Thank you, Mr Temporary Speaker, and I rise to speak on the Cognate Bill's Crime Sentencing Procedure Amendment, Sentencing Options Bill 2017, Justice Legislation Amendment, Committals and Guilty Pleas Bill 2017 and Crimes High Risk Offenders Amendment Bill 2017. Community expectations of the justice system have evolved over time. No longer is it enough to have a system that locks criminals in jails only to punish them and keep the community safe. In modern times, we have got a greater expectation of our justice system. We seek and indeed expect some form of rehabilitation for criminals and a subsequent drop in recidivism from those who have been punished within the criminal justice system. There are some who even seek justice for victims within this system, but I tell you, Mr Temporary Speaker, from my portfolio, that is not often achieved. This legislation has a strong relevance to my portfolio on the prevention of domestic violence and sexual assault. It's not enough, as I said, to lock up the perpetrator after a protracted court case where the victim's name and reputation is dragged through the mud in the face of a failure of the perpetrator to admit their crimes, and then have a blind expectation that perpetrators will change their behaviour if we just cross our fingers and hope for the best once they are released from jail. That is an unsophisticated, expensive and ineffective approach to delivering justice. Indeed, we know that some victims do not report violence as they fear that by calling all of the power of the justice system down on their perpetrator, there is little chance still of them achieving a conviction, and even if a conviction is achieved, there will be no change in the perpetrator's behaviour, and they will continue to be subject to violence and abuse. Victims and indeed our wider community deserve a fair legal system, and the four main elements of these bills go further towards this, with incentives for early appropriate guilty pleas, better sentencing options which recognise the importance of early intervention and access to programs as the best way to reduce recidivism, the need for effective and clear supervision for parolees, and specific strategies to deal with high-risk offenders. The former Labor government acknowledged this evolution of attitudes that I've spoken about today with the introduction of intensive corrections orders known as ICOs, which are today enhanced by these bills. The justice system, as I've said before, does not work effectively for victims. We see time and time again in our electorate offices victims of domestic violence and sexual assault who are living lives in fear of their perpetrators. We see the lengthy delays in the court system impacting on people's lives as they are caught up in the New South Wales criminal justice system, sometimes concurrently with the family law systems, and sometimes with conflicting outcomes and orders between those two systems. And it is an old cliche, but we do know that justice delayed is justice denied. Waiting for an accused to plead guilty at the last minute takes too long. It causes ongoing trauma for victims and delays in the system. With the introduction of video evidence in domestic violence cases, for example, we know that some accused are pleading guilty earlier, and there are some improvements coming in this area of the law. But we need to give perpetrators every opportunity to own up to their behaviour and actions. Clearly, we need a more timely response from the justice system, and this can only be achieved by allocating more funding in terms of judges and magistrates to hear cases, reducing court waiting times, ensuring that those defendants who admit their crimes are given an incentive for an early guilty plea. But unlike the member for, I don't know where he's from, Epping, sorry, I just lost that for a minute. Unlike him, I don't think it's just about a discount on your sentence. I think that we need to provide real opportunities for perpetrators to change their behaviour. And we know that if you live in a regional, rural or remote area within this state, that you have less access to rehabilitation, you have less access to drug and alcohol programs before you get to the stage of interacting with the criminal justice system. It's a breakdown of our whole community, and the member for Port Stephens was very articulate in outlining in her community the predeterminants of criminal behaviour, the breakdown in families, the lack of access to programs, lack of access to education, all those precursors that we know cause people to lose hope, to suffer mental illnesses, to become drug addicts or addicted to alcohol or other issues, which can then land them in a situation when they're in jail. And we know that of those who are incarcerated in this state, there are very many of them who are also people who suffer mental illnesses and addictions and, in some cases, intellectual disabilities as well, or who have themselves been victims of family or domestic violence or other forms of trauma. And so we have a cycle of trauma here which we need to address before it comes to the court. Clearly we need to have better sentencing options also, which recognise the importance of early interventions and access to programs as the best way to reduce recidivism, so that when people do come into the criminal justice system as perpetrators of crimes, they are given a chance. There are too many stories in our state of young people who have become very strong recidivists and who have committed many crimes and paid, sometimes with their lives, because the criminal justice system has not met the needs of those people. Short prison sentences generally provide no option for rehabilitation or so-called early intervention programs, as prisoners are not eligible for programs. In fact, it was very ironic last year when the government introduced early intervention programs for prisoners who had prison terms of 6 months. That it's like, let's shut the gate after the horse has bolted here. By the time you're in the criminal justice system as someone facing a criminal sentence, you are no longer in early intervention territory, and something should have been done in terms of community service audits or community service programs or drug and alcohol or mental health or whatever the thing is that you needed, the intervention needed to become before you got to that system. Now, victims deserve more, but so indeed do perpetrators. When we know that many of those people who perpetrate crime, particularly perpetrate violence, were once themselves victims or witnesses of violence, we must do more at an earlier period in their lives to work for change. We can never excuse perpetrators, but we must ensure that they are given the best opportunity to stop offending. And this bill ensures that for every sentence, every perpetrator must not reoffend, must undergo supervision, and must undertake at least one other appropriate condition, including curfews, home detentions, treatments, programs or injunctions regarding places or persons. But again, I say to the government, you can do all this for people who are convicted of crimes. Why cannot you do treatments, programs? Why cannot these be more widely accessed by people in our community before they are interacting with the criminal justice system, before they are perpetrating crimes? Why can't we target these people and make sure that they are given the support before they become the problem? We must do everything we can to support perpetrators to change their behaviours, and I've spoken to many people who operate perpetrator behaviour change programs in our state, and the lack of funding certainty, the lack of funding for long-term evidence-based programs is certainly a concern. Perpetrator behaviour change programs that are 6 to 12 weeks are not effective. We need these programs to be 6 months or 12 months. You cannot unlearn a lifetime of trauma and violence in a few weeks, and you really need support throughout that, and there needs to be support for the victims and the families as well, particularly in cases of domestic violence. It's also not just about perpetrator behaviour change programs, but also the way that parole operates. We need better supervision and ensuring that whatever sentences and directions that perpetrators and prisoners are given to programs to transition into are actually followed. My concern is, again, mirroring those of the member for Heffron, the member for Liverpool, about the funding for this, and to make sure that it is actually spent, and that it's not just about corrections orders, but, as I say again, have those programs accessible. In any justice system which acts to achieve real rehabilitation, we must ensure that prisoners are able to transition effectively back into the community, and this involves a level of supervision and support from parole officers. We need community corrections officers to be empowered to act on the spot in relation to breaches and provide immediate sanctions where appropriate. And I ask for a short extension of time, Mr Temporary Speaker.
Member for Maitland's request of extension of time. Is extension of time allowed?
It is.
Thank you.
An extension of time, member for Maitland.
Thank you. So I was just saying we need community corrections officers to be empowered to act on the spot in relation to breaches, providing immediate sanctions where appropriate, and where, for example, in case of domestic violence, where a breach of a parole condition, perhaps going to an ex-partner's home, has occurred, we want parole officers to act before there is another incident of domestic violence, not after the fact. There's also, I turn now to the bill in relation to high-risk offenders, and there have been a number of high-profile cases of high-risk sex offenders and domestic violence offenders that have come to light in the media recently, where the impending parole applications of particular prisoners have not been communicated to their victims for various reasons, and some of these are quite complicated in relation to where they were perhaps a child before the court, during the court case, because they might have been a child victim of sexual assault. So we need to make sure that that is covered in the bill, and I'd be interested to hear what the attorney has to say about that. There's also been a large outrage in some cases where there's been absolutely no faith by the community that particular prisoners will comply with parole orders. So we want the emphasis on community safety to be paramount in court determinations. We do want to expand the ability of victims of crime to share the extent of the impact of the crime on them and their lives, so that they can give their victim impact statements orally instead of having to be written. That is a good outcome. We want the courts to have a more comprehensive list of issues to consider when making an order, to include whether the offenders are likely to comply with the orders and the options available either in the community or in custody to reduce the risk of reoffending. So, Mr Speaker, I again call for the government to really work with our community in a more comprehensive way. It's important and it's good that this legislation is looking at an evolved approach to justice which looks at rehabilitation and reducing recidivism. But again, I say we must look at early intervention. We must look at building a community where people have opportunity and they have real supports around them when they are in need, rather than constantly having to wait until they have committed a crime before they can actually address the issues that have led them into that lifestyle. And it's not to make excuses for perpetrators, but we understand that living in violent homes, living a life of disadvantage, having little or no access to education, having a mental illness, having an addiction, these are all determinants of crime and leading to that, and we need to do more as a community to do that. We need to do much more in regional and rural and remote communities. We need to do more in Aboriginal communities. We need to do more with women. Like the member for Port Stephens, I was at that breakfast last week, empowering women, changing lives, and hearing the stories of families who are torn apart by custodial sentences in this state, of children who grow up with a life sentence for the short sentence that their parents, particularly their mothers, have received for sometimes crimes that they should never have been in a position that they were going to commit them. If they had had some more support from our community, perhaps they would never have interacted. So I urge the government to continue to work towards a fair allocation of resources in our community, to supporting those in need, and to ensuring that we do not need custodial sentences for our community. Thank you.
I thank the member for